L. Chandra Kumar versus Union of India, 1997. As per the original Indian Constitution, both the Supreme Court and the High Courts have the power of judicial review. This power, conferred under Articles 32 and 226, is a part of the basic structure of the Indian Constitution. However, the power of judicial review of High Courts became questionable when Parliament tried to give that role to tribunals. Can the power of judicial review under Articles 32 and 226 of the Indian Constitution be curtailed by an act of legislature? This question became prominent when Parliament enacted the Administrative Tribunals Act to give effect to the law under Articles 323A and 323B. In L. Chandra Kumar versus Union of India, the Supreme Court held that tribunals or other such courts can act as supplements to the High Courts but cannot take away the power of judicial review. Background: Part 14A of the Constitution was inserted through Section 46 of the Constitution 42nd Amendment Act of 1976 with effect from March 1, 1977. The amendment inserted two articles dealing with tribunals in India, that is, Article 323A and Article 323B. These provisions curtailed the power of all courts in India except the power under Article 136 of the Supreme Court. The legislature also enacted the Administrative Tribunals Act to give effect to the law under Articles 323A and 323B. Hence, this case challenged the constitutional validity of the Administrative Tribunals Act and dealt with the question whether Articles 323A and 323B can curtail the power of the Supreme Court and High Courts under Article 32 and 226. Legal issues involved. First, whether the subclause D of Clause 2 of Article 323A or subclause D of Clause 3 of Article 323B of the Constitution totally excludes the jurisdiction of all courts except that of the Supreme Court under Article 136 in respect of disputes referred section itself. Whether the tribunals constituted either under Article 323A or under Article 323B of the Constitution possess the competence to test the constitutional validity of a statutory provision or rule, or whether these tribunals, as they are functioning at present, can be said to be effective substitutes for the High Courts in discharging the power of judicial review. If not, what are the changes required to make them conform to their founding objectives?